If you die as an Arizona resident, then your property is going to be disposed of one of three ways. First way is you've got a will that says who gets your property. Second way is you've got a trust, and the trust provides who inherits your property, and that happens automatically without the need for probate. Now, the third way that your assets can be distributed is by the family or somebody opening a superior court probate. The purpose of the probate is to collect the assets of the decedent, to pay the expenses of the decedent, and then transfer the assets of the decedent to the people who are entitled to inherit those assets. Now, in Arizona, we have exemptions from probate for small estates. And that means if a person dies and they have less than $75,000 of personal property, then the family can get an exemption and fill out an affidavit, and the family doesn't have to do probate. Instead, the probate's going to pass according to the will or according to the law of intestate succession, which I'll explain in a second. Now, if somebody dies and they have real estate that's under $100,000 in value, then the family can also use an exemption and not do a probate for that real estate. So probates are only required when the assets of a deceased are worth more than $75,000 if it's personal property, and or more than $100,000 if it's real estate. And when a probate's required, somebody needs to open the probate and ask the court to appoint him or her as the personal representative. The personal representative is a person who is in charge of the probate after being approved by the superior court. And the personal representative job is to collect the assets, pay the expenses, and then distribute the assets to the desired people. Now, we typically can do a probate for $3,500 approximately for an uncontested probate. And it takes a minimum of 5 months to go from start to finish because although there's not a lot necessarily happening, we have to file a notice in a newspaper about the death and the probate, and then creditors have 4 months to make a claim against the estate. So we can't close the probate until that 4-month newspaper period passes. If you do have to do a probate, the good news is it's not going to be a terrible thing in Arizona, but you need to determine, first of all, take an inventory of the assets of the deceased person, determine the value of the personal property, determine the value of the real estate, and then determine whether you need to do a probate or you can use an exemption affidavit for the personal property and real estate. If you do need to do probate, real estate affidavit exemption, or a personal property exemption, we can do all three of those for you. We are probate attorneys. First of all, community property only applies to Arizona residents and only if they're married. So a single person is not subject to community property laws in Arizona. But when a married couple are residents of Arizona, Arizona law provides that all the property that each person owned before marriage is their separate property, meaning that person owns 100% of it and the other spouse doesn't own any of it. But Arizona law also provides that all property acquired during marriage is automatically community property when it's acquired, unless it's from a gift or from inheritance. So what we see a lot of times is people will go down and form an Arizona LLC themselves, and the person's married and they only name themselves on the articles of organization. The spouse is not named, and that person usually believes erroneously that that means that the person named in the articles of organization owns it as separate property and the other spouse doesn't own any of it. Wrong. It's community property even though only one spouse is named in the articles of organization. Now, there's two types of community property. There's community property and community property with right of survivorship. So in the example that I just gave where somebody formed the LLC and didn't name the second spouse on the articles of organization, that's community property. It's not community property with right of survivorship. Community property with right of survivorship means that both spouses have a joint interest, and that if one dies, the interest of the deceased spouse automatically passes to the surviving spouse without the need for probate. But the only way you can get community property with right of survivorship is there has to be some document signed by the parties where the husband and wife both acknowledge that the asset is community property with right of survivorship. So if the asset is community property, meaning each spouse owns an undivided one half, but it's not community property with right of survivorship, that means if one spouse dies, the interest of the deceased spouse may not automatically transfer to the other spouse. But with a community property with right of survivorship, if one spouse dies, the interest of the deceased spouse automatically transfers to the surviving spouse without the need for a probate. So when we do an operating agreement, for example, and the owners are husband and wife and they want to own as community property, we put language in our operating agreement that says that the two people agree that their interest in the company is owned as community property with right of survivorship, and then they're signing the operating agreement, so that legally creates community property with right of survivorship. So the bottom line is, if you're married, you want to own it as community property with right of survivorship. And if it's not community property and then it's separate property, then that's fine. But each person needs to be aware that they need to make sure that the separate property is not commingled with assets of the other spouse. Because if you take separate property in the bank account that you inherited from your parents and you put that into a joint account with your spouse, you just converted that separate property into community property. So take care when you have separate property that you don't inadvertently convert it to community property. When we do an estate plan, we also prepare, in addition to a trust and a last will and testament, we prepare ancillary documents such as a living will. A living will is an important document. That's where you give instructions to the doctors and hospitals that if you are brain dead and being kept alive by a machine, you want the doctors and hospitals to pull the plug. So the advantage of the living will is it takes that decision out of the hands of your family, because it can be very distressing to a family member to have to make a decision. Do I ask the doctor to pull the plug or not? So it's better when you have a living will, because you're making the decision to pull the plug. Your family member is not going to make that decision. Now, another important document in an estate plan is your healthcare power of attorney. And this is where you name somebody first in line to make medical decisions if you can't. So you can have a second in line person and a third in line person, however many people you want. So very important, you want to make sure that if you are unable to communicate with the doctor, the person that you want to make medical decisions for you is named in your healthcare power of attorney, and that you can then give that to the doctors. Now, one of the things that we do in our estate plan is we buy a 5-year membership for our estate planning clients with an organization called DocuBank. And DocuBank takes the healthcare power of attorney, the living will, and the HIPAA authorization, and it holds them on file 24/7, and it gives our client a little ID card that they can carry in their purse or wallet. It tells the doctors and hospitals that if there's an emergency, let's say you're in a hospital in Los Angeles, the ID card will tell the doctors and the hospitals the name and phone number of your emergency contact. And it will also tell the doctors that they can contact DocuBank 24/7. And DocuBank will fax to the hospital your healthcare power of attorney, your living will, and your HIPAA authorization. So that's real important if you are in the hospital, because if your paper documents are in your closet in your home, that's not going to be helpful to the doctors in Los Angeles, as they need to see those documents, and that's where DocuBank comes in. Now, we also prepare a healthcare ancillary document called a HIPAA authorization, and that's a document where you authorize your healthcare agents to get information about you from the doctors and hospital, because a federal law called HIPAA says that the doctors can't give out information about patients except to people who are authorized to get that information, and that's what the HIPAA authorization does. Now, another document we prepare with an estate plan is a financial power of attorney, and this is a document where you name the person who you want to give the power to deal with your financial affairs if you're unable. So if you're in a coma, the person who's named first in line on your financial power of attorney can deal with your financial affairs. They can write a check on your checking account, pay your mortgage, pay your car payment, do whatever is necessary. So the financial power of attorney is a very important document. Now, we also prepare a deed to transfer your home to your trust, and we give you a document called personal property memorandum. This is a document where you can designate who you want to inherit specific personal property items. So let's say you have a piece of jewelry and you want that to go to your best friend, or you want it to go to a sibling. You can designate on the personal property memorandum the description of the personal property item and then say who's to inherit it. So that means that if you die, that item doesn't go into your trust. Instead, it goes to the person that you've named in your personal property memorandum. There is this thing out there called the federal estate tax. And the good news is that for people who die in 2024 and 2025, there's no federal estate tax if the net value of their estate is less than $13,200,000. Now, the $13,200,000 exemption is going to go away in 2026 unless Congress extends it. So that means in 2026, the $13,200,000 exemption is going to go to half of that amount, increased by inflation. So we don't know at this time what the exemption amount is going to be in 2026 and later years, but it's going to be roughly $6.5 million or $7 million as opposed to the current $13,200,000. For Arizona residents, the good news is there's no estate tax. Regardless of the value of an Arizona resident's estate, Arizona does not have an estate tax. We all like to procrastinate and not think about death, but we all know that it's going to happen. And so it's important that you plan in advance. Now, one of the things that you should know if you're an Arizona resident and you don't have a will or trust is you need to know who's going to inherit your assets if you die. Because Arizona has a law called the intestate law, the law of intestate. And that law provides who inherits if a person dies without a will or trust. So we have an article on our website that describes this Arizona law that provides who inherits if you die. And we even have a quiz. You can take the quiz and it'll tell you who's going to inherit your assets if you die. Because if you don't have a will or trust, Arizona's law of intestate succession may cause one or more people to inherit that you don't want. I had a terrible situation some years ago where a woman called me and she was interested in doing a probate. And then she told me that her longtime significant other, they had been together 19 years, that the man died without a will or trust and he owned 9 rental properties. And that meant that the woman who was his significant other didn't inherit anything from her lover. Instead, the 9 real estate properties went to the man's brother because Arizona's law of intestate succession says if person dies, not married, no children, no parents, then it goes to the siblings. So the person who inherited these 9 properties was a brother that the decedent had not had any contact with in over 30 years. So it's important if you don't have a will or trust. Number one, you need to know who's going to inherit your assets if you die. So you need to look at our article and take our quiz and determine who's going to inherit your property if you die. Because if it's not the right person or people, you need to do a will or trust to make sure that your loved ones are protected.